Okay, in this video we are going to talk about intellectual property. And again, as part of your write-up, this is something you can discuss in the risk management section, but all really throughout your project, and the type of intellectual property that you might have for your business and ways that you can protect it so that it's not used without your permission or so that you're compensated. And also to make sure that you're not using somebody else's intellectual property, you're not violating a trademark or a copyright or a patent, that kind of thing. So first of all, the term intellectual property is sometimes called IP. Intellectual property is basically the idea that you have rights to non-tangible type of assets such as an invention, which may be a design, a formula, a biological, like a type of plant, or a seed, like here in the valley we have patented grass seed. So basically you have rights to the invention, the design, the product, whatever, and under law you will then have, with a proper patent registration, 20 years of protection, meaning that nobody else can utilize that invention, design, formulation, whatever the case may be, without your permission, which is usually done in the form of a license agreement authorizing somebody to use your invention and the rights to market it in exchange for a payment such as a royalty or a percentage of the profit or some other payment arrangement. So that is a patent. The idea of intellectual property involves those kind of activities along with others. So a patent is protection for invention. Now patents are very technical. I'm not a patent lawyer. I know just enough to know to call a patent lawyer when I have a client that needs that type of work. Patents are available both at the US federal level and then also on a worldwide level through international treaties with the World Trade Organization, the World Intellectual Property Organization, and other type of international organizations that will register international patents so that you have protection not only in the United States but potentially throughout the world for those countries that are part of the treaties, and even perhaps countries that are not part of the treaty, depending. Now I'm not going to get into the mechanics and details of how you go about filing for a patent. If you are in the area where you may want to file for a patent, that is done through the Patent and Trademark Office, and it's something that you're going to want to talk to a lawyer about. Oops, sorry, down here at the bottom. For a patent. You can look up patents on the U.S. Patent and Trademark website, which we'll get to in a minute. That's uspto.gov. And there is the ability to search patents there, although it's very tedious and not super easy to do in terms of a patent. All right, let's talk about trademarks. Sorry, I kind of got out of order there. A trademark is a mark that is used to identify a business, a product line, a service, or other type of business activity as an identifier for a business or a product. And the idea of a trademark is that you have rights to the trademark, which may be a logo, it may be a sound, like the NBC, dun dun dun, or like when you log onto your computer, Microsoft makes that little sound and all that stuff. You know, it's an identifier for a product or a company or some other way to identify your type of business. It may be a color, like Owens Corning pink fiberglass, insulation for housing. Or it may be a shape, like the Coca-Cola bottle. Or it may be a logo, like the logo for a sports team. Or any other, like the Nike swoosh and that kind of thing. So the idea is, this is a way to identify a business or a product. So trademarks, the way that it works is you automatically, to a degree, get rights to your trademark when you use that mark in the stream of commerce. And basically, whoever first used the mark either the name of the business or the product or the logo or whatever the case is, first in time has first in right. That's the saying. And that basically means that if you're the first to use it, you have superior rights to others. And they cannot use that name or that logo or whatever if it's yours without your permission. And so one of the things in business for protecting your trademark is you want to be able to make sure that you can document when you first started using that name. Now that may be easy to do because you filed the business name with the Secretary of State by filing articles of incorporation or whatever. You can also file for a trademark with the Secretary of State. But other ways to establish that are, for example, if you're doing a website, you can establish when the website was first created, when it was first published. Or another way to do it is maybe you come up with a logo, email it to yourself. That will establish, the time that you're using it. Email it to other people. That way you have a paper trail. So you're going to want to keep a folder on your intellectual property, including your trademarks and copyrights. And the idea is that you can document when you first started using that name, logo, whatever the case may be, in an easy way to document it. It's a good idea to both have a hard copy and a digital copy. That way, if you need to use that for evidence later on, you have that available. Now, again, a trademark comes into, you get it automatically in a matter of speaking. However, in order to be able to enforce it, you have to register with the U.S. Patent and Trademark Office at uspto.gov. And it's a fairly easy process to do. Last I looked, it was about $350 on up to be able to register it. And basically you register, you put the name, the logo, you maybe upload a logo file in a PDF or a GIF or whatever type of a format, and register that. Now you can also search for trademarks on that website. So let's just take a look at it real quick. So this is the U.S. Patent and Trademark website, uspto.gov. And this is where you would register a patent. And you can also do patent searches. And then for our purposes right now, we're talking about trademarks. So you can see right here, trademarks. So I want to do a trademark search using TESS, which is a trademark search database. So I'm going to look up the word Nike to see if that's been used as a trademark. And let's just see what's out there. And you can see here there's a number, as you would expect, of Nike trademark registrations. And you can go through and check those out. And the way that you use this, number one, when you're starting a new business or coming up with a new business name, you're going to want to check to see if that's already been taken, if it's out there in the trademark, if it's an active trademark, and also to see if the trademark, the way it's registered, falls into the same type of business category that you're doing. If I'm doing a play about Nike, the Greek goddess, which is really maybe totally different than shoes and sporting goods, it's a little bit different. So, or perhaps not, I don't know. But the idea is, you can look to see if somebody's already registered that name, if it's active, and if it's in the same type of business environment that you're going to be doing. One, to make sure you're not going to infringe on the trademark, and then also to see if that name's available. And part two to that is, this is also the website where you would go to register the trademark. Just click on Nike real fast for fun. And there's the Nike logo right there. I don't know if you can see that or not. Yeah. There's the Nike logo. Downloadable virtual goods, clothing, footwear, headwear, eyewear, etc. All the designs and all that. So you can see what the trademark is. Okay. You can also apply online for your trademark. Now, I'm not going to go through all that. That's sort of a different class. But I just want you to be aware that this is where if you want to go ahead and register your trademark, this is a place that you can do that. Now, again, from a financial risk management standpoint, if you've got to design a product that you know you're going to be using and it makes economic sense to spend $300, $500, whatever the fee is at the time to register that trademark, that's the best protection you can have. However, maybe you have a number of different products and you're not sure which ones are going to sell. Some may not sell, and so you just don't use the name anymore. And really, maybe you have 10 products, but you're not sure what name you're going to use. And registering all of those, maybe $3,000, $5,000, $7,000 in total fees by the time you get that all done. So again, the idea is you have the right to the trademark without registering it, but in order to enforce it and to secure that protection, it must be registered. So back to being able to prove when you first started using that product name or logo or whatever in the stream of commerce. One of the other things you can do here in Oregon is you can register a trademark with the Secretary of State. I don't remember the exact fee off the top of my head. I want to say it's like $50, but it's a lot cheaper. And that also is a way that you can put that out into the public record without the additional higher expense of US PTO filing. And then later on, if you want to go back and file the federal trademark, you've already established that name in the stream of commerce. Oh, one other thing I should point out. Well, I'll get to that in a moment. All right. Okay, next we have a service mark. I'm not going to spend a lot of time on that, but basically that is a trademark for a service industry. So H&R Block tax preparation, or financial services, State Farm Insurance, or other type of service industries. Could both be a trademark and a service mark. And again, the registration process is basically the same for that type of service. Next we have a copyright. A copyright is a protection for a work of art, literary works like books and magazines and articles, movies, music, and other type of creative arts. And this gives the owner, the author, the songwriter, the movie producer, whatever the media is, rights to that work of art exclusively during their lifetime, and then right now it's typically about 50 years post-death. Part of it depends on when it first happened. So this is essentially the ability to protect your intellectual property arising out of artistic endeavors. Now again, like a trademark, you have automatic rights. If you are the author, you automatically have the trademark. You must register it, however, to take certain enforcement actions, but just the ability to prove that you are the author gives you those rights automatically. And again, this is something you want to document, email yourself or do whatever to have an intellectual property file to be able to document when you first came up with it. All right. We've talked about patents, a license. The word license refers to permission. And so in the terms of intellectual property, this is the standard way that use of intellectual property may be granted to another party that's not the owner. So for example, let's say I want to put together sporting apparel that has the Western Oregon logo on it. And so I would have to get permission from Western Oregon University or Oregon State or the Ducks, to use their logo to put on shirts or hats or whatever, because I want to sell those. So I will have to typically pay a licensing fee and then perhaps a royalty, which is a percentage of my sales, or depending on how they structure their fee. Same thing with music. If I'm a musician and I want to allow people to play my music in the elevator or whatever, they would have to pay me a royalty, or movies, et cetera, et cetera. That's all done through a licensing and royalty agreement. depending on the type of activity or intellectual property involved, be it a patent, a trademark, or a copyright, or whatever, or a service mark for that matter. All right. Again, down here, number 6, website. So let me just talk about this real quick. What I'm referring to there, website internet protocol.com issues, basically. So let me explain what I mean. So let's say I want to start a new business and I want to come up with this catchy name, and I want to have the name of the business .com or .biz or some other website. So what might be a good strategy, and this can all be done within literally minutes of each other, is I'm going to go, first of all, register and see if the name's available by doing a search function on the Secretary of State website and the trademark. But I'm not going to register the name with the Secretary of State yet. First, I'm going to go secure the website that I want, assuming it's available. So let's say I'm going to, hasbrouckhotdogs.com. So I'm going to go file for the website hasbrouckhotdogs.com before I file for Hasbrouck Hot Dogs LLC with the Secretary of State. Now again, I'll do this within minutes of each other, but the idea is when I register with the Secretary of State, there are people that watch those filings, and they will go out and register the .com name for the new filing, and then they'll try and sell it back to you. Now whether that's legal or not is kind of in a gray area, but this is sort of poaching, and the idea is to avoid that potential problem, you might want to go ahead and lock down the internet property, the .com name or whatever, before you actually register with the state and it becomes public record. Now, if you're internet savvy or whatnot, it's pretty easy to do, even GoDaddy.com or something like that, to lock up that name. It's not very expensive. And then you can register the actual name with the state when it becomes public record, and that way you've locked that all down. That's just sort of a strategic standpoint that you might want to take into account when you're protecting your intellectual property. Finally, down here I have uspto.gov, and that's where you go, which I showed you the website earlier. Now for your project, one of the things you can do is you can write up what type of intellectual property you might have, an invention, a trademark, a copyright, or whatever the case may be, and then tell me what steps you're going to take to protect those rights. And that's really part of part 3, well, part 1. You can intermix that anywhere within your project, but the idea is that's how you're going to protect those rights so you don't lose those rights. And you can talk about what registration steps there are, what costs are involved in that kind of thing. If you have a logo, go ahead and include it, that kind of thing. All right, so that's pretty much it for this section.